At 2006 in the afternoon, I watched the defendant do something I've seen 100 times in my career. He treated a federal courtroom like a negotiation room. And then, in less than 5 minutes, the court treated him like what the law says he is when he violates release conditions: a detained defendant. Let me be precise about what this story is and what it isn't. It isn't about politics. It isn't about whether you like the defendant. It's about the machinery of federal court conditions of release, witness integrity, and the moment a judge decides you cannot be trusted outside a locked door. The defendant, call him Everett Lane, was 52. He ran a regional chain of investment education offices that promised ordinary people they could turn a few $1,000s into financial freedom. The indictment called it what it allegedly was: a funnel for fees, fake account statements, and a pressure sales machine built around lies that looked sophisticated enough to fool retirees and first-time investors. Wire fraud, conspiracy, money laundering, and false statements count for good measure. But what brought us into court that day wasn't the indictment. It was what he did after the judge gave him a chance. He'd been released on bond 6 weeks earlier. Standard conditions with a few extras because the government had already raised concerns: no contact with potential witnesses, no destruction of documents, no new devices not disclosed to pretrial services, and no third-party communications through intermediaries. He agreed to all of it with the smooth confidence of someone used to talking his way past consequences. That confidence sat on his face when he walked into the courtroom. The hearing was a routine status conference on paper. Defense counsel expected scheduling deadlines, motions, maybe a trial date. But the government didn't bring a scheduling binder. They brought an emergency motion to revoke bond. And you could tell that immediately because the prosecutor didn't start with pleasantries. She stood, placed one folder on the lectern, and said, "Your Honor, the government moves to revoke the defendant's release under 18 U.S.C. Section 3148. Bail revocation." Those words are a trapdoor. The judge didn't react emotionally. He never does. He just asked one question, and it was the question that matters more than anything in these proceedings: on what basis? The prosecutor answered with a timestamp: "Sunday night at 9:41 p.m., Your Honor." That's not a random time. That's a prosecutor telling the court, "We can prove this down to the minute." At 9:41 p.m., she continued, the defendant sent a message to a cooperating witness, instructing her to destroy handwritten notes related to the scheme. Everett's lawyer shifted his weight. Everett himself didn't. He stayed relaxed, almost bored, as if he'd already decided the judge would be annoyed at the prosecutor for making a fuss. That's the mindset that ruins defendants, believing the judge is judging style, not facts. The prosecutor lifted a single page. "We have the message, Your Honor," she said. It was sent from a number associated with a device the defendant failed to disclose to pretrial services. Undisclosed device. That phrase does two things at once. It tells the judge you hid something from supervision, and it tells the judge you plan to hide more. Defense counsel stood fast. "Your Honor, objection to foundation. We don't know." The prosecutor cut in gently, the way experienced prosecutors do when they have receipts. "We have carrier records. We have location data placing the device at the defendant's residence at the time of transmission. And we have the witness's testimony that she recognized the defendant's language and phrasing because he used it repeatedly during the operation." Then she read the message, and I'm going to quote the key part because the language matters. "Burn the notes, not shred burn. No photos, no backups." That's not bad judgment. That's a consciousness of guilt instruction written in plain English. For the first time, Everett moved. Not much. A slight tightening in his jaw. The judge looked down at the page, then up at defense counsel. "Counsel," he said, "is there any dispute the defendant is under a no-contact order with respect to witnesses?" Defense counsel tried to widen the lane. "Your Honor, we understand the order, but the government is labeling—" The judge stopped him. "That was not my question," the judge said. "Is there any dispute the order exists?" Defense counsel answered the only answer he could. "No, Your Honor." The prosecutor didn't waste the momentum. She built the record brick by brick, like you're supposed to in federal court. "First," she said, "the defendant contacted a witness directly. Second, he used an undisclosed device. Third, he instructed destruction of evidence. And finally," she said, "after the witness refused, the defendant attempted contact through an intermediary." This is the moment when the courtroom changes, because now the judge isn't hearing one message. He's hearing a pattern of behavior. You're still operating. The prosecutor called the witness, not a dramatic figure, not someone looking for a spotlight. A former administrative manager named Talia Reyes, late 20s, who would handle intake paperwork for clients' names, payments, notes from sales calls, the parts of fraud that look clean on a spreadsheet but feel ugly in real life. She testified calmly. She said she'd agreed to cooperate 2 weeks earlier after agents showed her internal files and asked the simple question cooperators always get asked, is this legitimate? She said she told them the truth. Then she testified about the text message. He used to say, no backups, she said, like it was a rule. The prosecutor asked, did you preserve the message? Talia nodded. I took a picture of it with my laptop camera before it disappeared. That detail matters. The judge doesn't need to be told what disappearing messages are. The judge knows. Everyone knows. The prosecutor introduced the photo. It showed the message on screen. Same wording. Same time. Then the prosecutor pivoted, because these hearings are rarely about one thing. She asked, did the defendant contact you after you stopped responding? Talia hesitated. Then she said, yes. How? Through his assistant, she said. The assistant called me and said Mr. Lane wanted to clear up confusion and that I should remember who helped you. That's not a friendly call. That's pressure. Defense counsel finally got his turn, and he did what defense counsel does in a bond revocation hearing. He tried to shrink the issue. He argued the text could be misattributed. He argued the assistant's call was not under the defendant's direction. He argued the witness was motivated. He tried to put the toothpaste back into the tube. But the problem with modern evidence is it doesn't care about your argument. The prosecutor stood again. Your Honor, she said, we also obtained a recording from the assistant's phone, and you could feel Everett's confidence flicker, just slightly as if he realized the government wasn't guessing. The prosecutor played it. It wasn't a smoking gun confession. It was worse because it was ordinary. The assistant's voice said, he's stressed. He's saying you need to handle this. He said, burn the notes, no photos. And I'm just repeating what he told me. Repeating. That word killed the defense's best line, that the assistant acted independently. Now it wasn't independent. Now it was derivative. The judge leaned back and looked at Everett. Not with anger. With evaluation. This is what people misunderstand about judges. Most of them are not emotional in the moment. They are clinical. They're watching your behavior like it's a live demonstration of your future behavior. The judge asked, Mr. Lane, do you understand that instructing destruction of evidence is a crime separate from the underlying indictment? Everett tried to speak. Your Honor, the judge held up a hand. You will not speak, he said. Your lawyer will speak. That's not harshness. That's procedure. Judges know that defendants talking off the cuff can poison the record. Defense counsel tried a final rescue plan. Your Honor, if the court has concerns, we can propose stricter supervision, home confinement, more reporting, surrender of all devices. Propose. That word is the sound of a defense sliding downhill, because the judge is about to ask the question that ends the argument. What condition prevents him from doing this again? And that's exactly what the judge asked. Defense counsel didn't have an answer that matched reality because the entire problem was intent. A person who wants to contact a witness will contact a witness. A person who wants to destroy evidence, we find a way to destroy evidence. So the judge made findings, and he made them in a tone judges use when they want the appellate court to understand this was not a close call. I find by clear and convincing evidence, he said, that the defendant violated the conditions of release. I further find, he continued, that the defendant is unlikely to abide by any condition or combination of conditions. Then he said the sentence that turns a defendant's life into a controlled environment. Bond is revoked. The defendant is remanded to the custody of the United States Marshals. And this is the part people never forget when they see it in person. The Marshals didn't rush. There was no chaos. They stepped forward like it was routine, because for them, it is. Everett's face didn't explode into a dramatic expression. Real shock doesn't look like television. Real shock looks like a man trying to keep his posture while his brain realizes he miscalculated. His lawyer asked for a delayed surrender. 48 hours, a week, anything. The judge shook his head once, denied. Then the cuffs came out. That metallic click, small, sharp, undeniable, landed in the room like punctuation. And the legal reality crystallized. Everett didn't just lose a hearing. He gave the government something they love at sentencing: post-indictment obstruction conduct. Because obstruction isn't just a bad look. It changes guideline calculations. It changes the judge's perception of remorse. It changes the prosecution's posture in plea negotiations. It can trigger enhancements. It can erase acceptance of responsibility arguments. And it can turn a case that might have been negotiated into a case the government decides to try. And it tells the judge one thing that matters more than anything else in the pretrial phase: you cannot be trusted with freedom. So let me ask you the question I always ask at the end of stories like this, because I genuinely want to hear how you read it. When a defendant on bond tells a cooperating witness to burn the notes and uses an undisclosed device to do it, was immediate custody the only responsible decision? Leave your thoughts in the comments. I read all of them. And if you want more breakdowns that focus on evidence, procedure, and what actually happens in federal court, not social media hot takes, subscribe, like, and share.